Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt on 9:30 a.m. The Answer. Podcasts everywhere, talklawradio.com, Facebook Live, and YouTube. Subscribe to our YouTube channel and hit the little bell image so that you can be notified when we're downloading content or uploading content onto the YouTube page. Today we're talking about why Texas guardianship law is so complicated. With me is Sharyl Mays. She's a paralegal with Marquardt Law Firm. I like to say she's paralegal extraordinaire. She has over 20 years experience working in probate and guardianship. We've been talking a lot about why Texas guardianship is so complicated and difficult, and a lot of the reason is because a judge saying that you're incapacitated does take away your rights to do certain things, and it gives those rights to somebody else to make decisions for you to do or not do certain things. And I want to mention our sponsor, Joseph Warren with Financial Planning HQ. If you have any needs for planning out your financial future, contact Joseph Warren with Financial Planning HQ. So Sharyl, let's get back into guardianship. Tell us, what are some of the hoops that applicants have to jump through before a judge will award them the right to make decisions for somebody else?
So the first thing we're going to do when we're working with our applicants is ask them a couple of difficult questions about themselves. We need to know if they've ever been convicted of a felony. You know, that's not something that somebody openly shares.
Right.
And so when you are an applicant for a guardianship, you have to go through a training system through the Texas guardianship program and get training. Mm-hmm. You have to be fingerprinted. When you are a guardian of the estate, you have to be bonded to protect the assets of the ward. So we have to do a bond application to see if you even qualify for a bond. If you've ever filed bankruptcy or have had a bankruptcy in the last 7 years, that can impact your ability to serve as a guardian. And then also just what kind of person are you generally? If
Right.
you are an addict yourself or have been known to fly off the handle and have an anger issue or have had a bad relationship with this individual before, the court will take that into account. If another family member comes forward and contests your application, the court's going to ask why.
Right. So you mentioned the fingerprinting and background check. That's more robust now, right?
It is. So it's a centralized program. We provide you with the links and instructions on how to go through it. And then now, if you are just guardian of the person to take care of somebody's medical issues, you can do your fingerprinting through the system. But if you're the guardian of the estate now, you have to get special codes from the court, and it goes through the FBI fingerprint system now.
Okay, and so that is probably nationwide then.
Yes, they're going to get a nationwide background check on you.
And then going back to guardianship of the estate, when you're asking the court to give you permission to handle somebody's finances, you mentioned the bond. That's kind of like an insurance policy, right? That says if you happen to lose all of this person's money or steal all of their assets, then the insurance company will make the proposed ward whole again.
Correct. Yeah.
And in order for the insurance company to decide whether or not that's a good risk to give you that policy, they check your credit.
Yes, they check your credit, they look at your debt to income ratio, and then they take into account what the ward's assets are and what is needed to protect them. Mm-hmm. And the court will set the bond amount. So if you don't qualify for a higher bond amount, there's a few tricks and trades that we have within the probate system to get that amount lowered. But if you are going to need continual access to these funds to take care of the ward, then you may not be the best applicant for the situation.
Right. So decide whether or not you have decent credit. And that might be one of the grounds to contest if somebody's trying to become guardian of your loved one and you think that's a bad idea because it's a bad person, or they don't have the education or experience to manage funds or to manage the medical.
The other thing that I would want to say is acting as the guardian of somebody is a full-time job on itself. So if you already have a full plate and you're already struggling to help this person without a guardianship in place, it may not be the best fit for you. And there are certified guardians in our city that do an amazing job that can step in and do this for the ward and for you as their family member, so that you can still have that parent-child relationship with them, but not have the stress of the day-to-day taking care of somebody. Because it's like having a newborn infant.
Right. You're making all their decisions and paying all their bills and scheduling all of their appointments.
Talking to the doctors on their behalf, picking up the medication for them, spending Christmas Eve in the emergency room with them. You're on call 24/7, 365.
Yeah, good point to make. So after the lawsuit's filed and the applicant is getting their fingerprints done and checking to make sure they have decent credit so they can qualify for the bond, and then there's going to be some other investigators involved.
Yes.
One, another attorney that's appointed to represent the proposed ward to protect that person's civil rights, and an investigator by the court in the big counties anyway. I don't know what the smaller counties do.
Yep. So the court, once they get the application, gives it to the court investigator, who starts trying to meet with the ward and with the applicant. As part of the application, we have to list any Tier 1 family members. So if it's a minor, we have to list the parents and any siblings that they may have. If it's of an adult, if their parents are still alive, we have to notify them, plus all their siblings. If they have children, we have to notify their children. And everybody has a posting period where they have the ability to make a contest or a showing in the proceedings to say, yes, we agree with it, or no, we don't.
Yeah, and the proposed ward has to be invited also.
Yes, they have the right to be there.
Right, they have to be given a copy of the lawsuit delivered to them in person.
Yes, and once they're appointed too, there's the Bill of Rights that they have to be presented on an annual basis. When they go to the primary care physician to do the certified medical exam, they have to be Mirandized to know that they have the right to say yes or no, that they don't want to do this.
Yeah, that's a good point. You could have a very stubborn ward to deny, I don't want to answer any questions about my health.
Yep.
The Bill of Rights that you mentioned is specially adapted to this guardianship process. It's a list of rights that the ward has to make as many decisions as they can and have as much information as they can understand. It's not the first 10 amendments to the Constitution. It's a different Bill of Rights.
It is. It's a little more individual focused than the population as a whole.
Yeah, but it's important that we understand that even though a judge has decided that they're incapacitated, that they still have rights.
They do. They do. You can't just lock them away in a facility and forget about them. If you're the guardian of the estate, you have to file an annual account. You have to take very good records of what money you're getting on behalf of the ward and how you're spending it, not just to the court, but also Social Security, the VA, and all the other institutes that they may be.
Right. Yeah, the Social Security and the VA, they have their own accounting forms and process.
They do, and if they're receiving benefits from the VA, we have to let the court know that and put it on the pleading so that the court knows that it's another reporting institution.
Okay, so the attorney ad litem, that ad litem is just Latin for, I've always remembered it's just for this case.
Yes.
I don't know how it translates exactly, but that's what it means, that the attorney just represents the proposed ward to make sure that all the steps are followed. And if the proposed ward says, no, I don't want this, I want you to squash this application for guardianship, then the attorney ad litem has to make a good effort to force everybody to prove their case or to get the case dismissed.
Yes, and even beyond that, if it's a contested matter and the applicant wants the guardianship and the ward doesn't, but there's still ongoing acts against the ward's best interest, then a guardian ad litem can be appointed and take control for a temporary amount of time.
That's right. There's another position, another attorney that could get involved called the guardian ad litem, who's just temporary. That's a lot of detail we'll have to get into another time. But we're going to take another break. When we come back, we'll try and wrap this up for you, so stay tuned.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.